Welcome to this brief exploration of how the Irish legal system protects our most vulnerable participants, child witnesses. How wide is the gap between stated policy and implemented practice? Today we examine the delicate balance between upholding the integrity of the law and ensuring a child's voice is heard without causing further trauma. We will cover family law proceedings, child complainants in criminal court, and the critical competency tests for those witnesses under the age of 14. This is an area where the law tries to do two things at once: protect children while ensuring their perspectives are central to the outcome. However, we know that the law is only as effective as those enforcing it, and the enforcers can only do their jobs properly through the provision of sufficient resources and training. Our journey begins with the highest law of the land, Article 42A of the Constitution of Ireland, the very bedrock of these protections. But has this provision had the impact that we hoped for at the time of its enactment? Chapter 1. The Child's Voice in Irish Law. Let's look at how this right evolved from statutory discretion to a constitutional mandate. The recognition of a child's right to be heard is not new. Ireland first codified it in care proceedings via the Childcare Act 1991. Section 24 of that Act allowed the court to give due consideration to the wishes of the child. However, it was Article 42A of the Constitution, following a 2012 referendum and signed into law in 2015, that gave this right a much stronger, immutable constitutional foundation. Article 42A.4.2 mandates that, where a child is capable of forming their own views, those views must be ascertained and given due weight. This assessment must always have regard to the child's age and maturity, ensuring the law adapts to the individual's development. However, the phrase due weight is capable of a very subjective interpretation, and Irish courts have not really fully embraced the idea of genuinely consulting with a child. The Guardianship of Infants Act 1964 was amended by the Children and Family Relationships Act 2015, which introduced sections 31 and 32, where the court could consider the wishes of the child. This amendment was necessary to bring the Act in line with the recently enacted Article 42A. This is an area where the law tries to do two things at once: protect children while ensuring they are not just mute witnesses to the eventual outcome of the proceedings. For that law to be effective, the child needs to be listened to, rather than asked to answer a few cursory and often pro forma questions. It is also important to clarify that Article 42A does not mean the child decides the case, and nobody can argue with that. The judge remains the ultimate decision maker. However, the judge should be open to the idea of being influenced by the child and actively seeking out the child's thoughts and feelings on the matter at hand. The child is not being asked to choose between parents or carry the burden of the final decision. Their views are simply evidence that may impact the outcome. Furthermore, this is a right, not an obligation. No child should ever be forced to express a view if they choose not to, particularly in custody and access hearings. In practice, Irish courts often hear children indirectly through an expert assessor, keeping them away from the intimidating witness stand. In custody cases, the court can procure a report under Section 47 of the Family Law Act 1995. Similarly, for care proceedings, the court seeks reports under Section 27 of the Childcare Act 1991 to understand the child's perspective. Another law allows a judge to order that a report be provided about any issue that affects the welfare of a child. These reports are often called Section 32 reports, in terms of the Guardianship of Infants Act, or simply child welfare reports. Amongst other things, the section authorises a judge to appoint an expert to determine and convey the child's views. Judicial guidelines for preparing Section 47 and Section 32 reports stem primarily from the Family Law Courts Development Committee's guidelines and the recently launched Judicial Guidelines on the Commissioning, Preparation, Content and Usage of Expert Reports in Family Law Proceedings, April 2026. These emphasise child welfare assessments by qualified experts like psychologists, focusing on clear, court-directed questions, the child's views, and professional opinions with recommendations on custody or access. If safety is a concern, Section 20 of the Childcare Act 1991 authorises a court to ask the CFA, TUSLA, to carry out an investigation of a child's circumstances and report back to the court. These reports, sometimes requested by the judge in family law cases, are done by social workers. Section 20 reports are concerned with the welfare of the child and how the child can best be supported. It looks at the current situation the child is living in and any supportive or challenging circumstances that exist. It also looks at any relevant context and history and will mention any previous orders requested by TUSLA if this is relevant. The report also sets out whether TUSLA is making any application in respect of the child, any supports it has provided or intends to provide, and any other actions it has taken in relation to the child. Chapter 2. The competence of a child witness. How does a judge decide if a child is ready to testify? Irish judges receive mandatory training through the Judicial Studies Committee, JSC, of the Judicial Council, established under the Judicial Council Act 2019, which includes programmes on child-related matters in family and childcare proceedings. The JSC provides courses on communicating with children, the voice of the child, and avoiding re-traumatisation of vulnerable witnesses, including practical skills for child-friendly interactions. The primary statutory test for witness competency is whether the child can provide an intelligible account of events. It is a capacity test, not a moral one. First, communication ability. Can the child describe what they witness in a way that allows the court to understand what happened? Second, relevance. Is the account focused on material events rather than being confused or shaped by external suggestions? Third, reliability. While the evidence may be unsworn, it must remain credible. The child must appreciate what goes on in a court and must clearly understand the absolute need to tell the truth. Judges should implement this through preliminary questioning, using simple, open-ended queries to assess clarity without creating pressure. This questioning should be done in the judge's chambers with a social worker or guardian ad litem present. If, for whatever reason, the judge wants to conduct the assessment in the courtroom, that court must be cleared. Critically, unsworn evidence from a child under 14 is not lesser evidence. The law allows it to stand as firmly as sworn testimony. Chapter 3. Child complainants in criminal court. Here, the system balances testimony with protection from trauma. Under the Criminal Evidence Act 1992, special protections are deployed to shield children from the often harsh environment of the criminal court. Section 13 allows witnesses under 17 to give evidence by live television link, ensuring they don't have to face the accused directly. Most circuit and high court venues have video link capabilities for vulnerable witnesses. enabling testimony from dedicated rooms or remote sites to reduce trauma. However, significant gaps persist. For instance, in 2022, the Law Society reported that Court 55, which is the specialised children's court in Dublin, lacked video link infrastructure, limiting protections for child witnesses there. No confirmed public plans exist as of May 2026 to install video link facilities specifically in Court 55. Recent upgrades focused on platform-wide enhancements, like PEXIP Infinity for remote hybrid hearings starting March 2026, enabling virtual participation but not physical in-court video links for separate room testimony by vulnerable child witnesses. Whilst these changes support broader access, e.g., dial-in from 165 courts since 2025, they still have not addressed Court 55's specific hardware gap. Section 14 provides for intermediaries to sit with vulnerable witnesses and essentially act as interpreters, breaking down complex questions into child-friendly language, which can be heard in the courtroom and therefore confirmed as accurately representing the original question. The room is also filmed with a wide-angle camera so that the court can see the entire room, ensuring that coaching or prompting does not occur. When this section was created in 1992, it could properly be described as groundbreaking. However, it was never formally implemented, and if an intermediary was ever provided, it was on an ad hoc basis and not subject to any qualification guidelines. Today, although subject to certain amendments, the section has not substantively changed from its original wording in 1992. Therefore, the question of exactly what an intermediary does and what qualifications they require still remains legally undefined. Section 14.3 says, an intermediary referred to in subsection 1 or 1a shall be appointed by the court and shall be a person who, in its opinion, is competent to act as such. Since 2016, on occasion the Irish courts availed of the expertise of intermediaries from England and Northern Ireland. A diploma course to train intermediaries was established in the University of Limerick, and the first year graduated in July 2023, but the register only opened in April 2024, and the pilot scheme for the panel was hoped to be operational by the summer of 2024. Currently, there are 16 names on the national list of intermediaries. The Working Group on the Trial of Sexual Offences, chaired by Professor Tom O'Malley, found that the interventionist role was only one role that an intermediary might play. The group suggested that the intermediary can also exercise an important advisory role by assessing the witness's needs in advance of the hearing and advising the court and counsel in advance of the trial as to what kind of special arrangements should be made. An intermediary could also be used during the police questioning of a witness, and in particular the complainant, Professor O'Malley said. This would allow for involvement at an earlier investigative stage. Section 16 allows video-recorded statements from children under 14 to be admitted as evidence in chief in certain cases. These measures are designed to preserve the integrity of the evidence while shielding the child from the intimidating atmosphere of open court. Specifically, Section 27 of the Criminal Evidence Act 1992 governs unsworn evidence for those under 14 years of age. The judge must explore whether the child understands the difference between truth and lies and can communicate answers coherently. This is not a trap or a mini cross-examination. It is a simple inquiry into the child's actual capacity to provide usable evidence. Even if the child is found to be competent, the court retains discretion. If testifying would cause undue harm, the judge may rule that it is not in the child's best interests. Finally, good practice is essential. Interviews should be early, planned, and conducted in neutral, non-threatening settings. Children must be told it is okay to say, "I don't know," and that it is okay to correct the interviewer. This is important as children will see the interviewer as an authority figure and will therefore do their best to please that person and are naturally reluctant to point out mistakes made by the interviewer. By repeatedly assuring the child that the interviewer does not know anything about the child or their circumstances, and therefore will make mistakes, the child is reassured. This reduces pressure and increases accuracy. In Ireland, the child witness is protected by the constitutional right to be heard and the statutory procedures that make that hearing safe. However, a law is only as effective as those enforcing it, and our courts and judges could do a lot more in the effort to make the experience more child-friendly. The state could also do a lot more in providing sufficient resources to equip all courts with the necessary technology, to train sufficient professionals according to international best practice, and to ensure immediate provision of services to child witnesses everywhere in the Republic. This might allow Article 42A to be the force of change that it was meant to be. Our goal must be to ensure that children are not invisible, but participants whose voices matter in a system that is safe, careful, and fair.